Any mention?
Lordship, I beg to mention item 5.
Item 5.
5 and 6 are connected matters. Mr. Sen is in item 6.
There are a number of cases stuck together.
3
Is
cases.
that issue where the administration of the cantonment areas is still pending? The question of transfer is still pending.
How long it will remain pending? These are cases of 2018 and 19.
My lord.
Because you relate to not only this cantonment, all the cantonments we are giving. So it will take time.
It'll take some time. Lordship.
So when shall we list it?
After 3 or 4 weeks.
3 weeks.
Just on the request made by the parties, this matter after 3 weeks. 5 and 6. Same parties in 5 and 6. Councils are same.
No, my lords.
I'm in 5.
I'm appearing in 6
Seniors for 6.
for the petitioners.
Obliged. Please, Lordship. Should I beg to mention item 10, my lord? Bring for 2 weeks time, Lordship. I'm praying for 2 weeks time for preparing. My lord. He's what?
And 2 weeks on the request of the appellant.
Much obliged.
Obliged, Your Lordship.
Your Lordship, item number 13.
Yes, what happened? 13.
Your Lordship, may this matter be listed after 3 weeks, Your Lordship.
Who is the other side? You are mentioning for petitioner.
Petitioner.
Who is the other side?
13, I am for the state respondent, Lordship. No objection.
You are also there.
Private respondent.
No objection. This also after
3 weeks.
3 weeks on the request of the petition. 13. Yes.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 7, Your Lordship.
Yes.
Your Lordship, I pray for some accommodation in this matter, Your Lordship.
Mr. Gautam has objection.
My lord, just 1 week, my lord, not more than that, because lordship, this man is inside for quite some time. My lord, this is a criminal petition against conviction by the BSF Security Court. My lord.
This is a
We can hear it
2022
next week.
case. 2022 case.
My lord.
Your Lordship.
1 week. 1 week will do.
2 weeks, Your Lordship, I'm praying.
1 week should be fine, my lord.
His objection. We'll adjourn it for 1 week
1 week.
and make sure you take it up.
Okay.
7 on the request made on behalf of Mr. Dr. N. Vajika. DSG appearing for the respondent and is this matter after 1 week. Yes.
Much obliged.
Obliged.
May it please, Your Lordship, I
Yes.
beg to mention item number 15. Your Lordship, I like to pray for 1 week time, Your Lordship.
You are for the respondent.
Status the petitioner, Your Lordship. Is
1 week time for what? Oh, for this. Otherwise,
For
ready,
hearing.
said-
yeah, it's already. Your Lordship.
Okay. This list after 2 weeks on the request made on behalf of the respondent.
Highly obliged, Your Lordship.
Obliged, Your Lord.
May it please, Your Lordship. Lordship, I beg to make a mention of item 4.
Item 4. Why? What happened?
Lordship, Senior Conducting Counsel is having personal difficulties, Lordship, today.
Oh, that is that matter which was
Teachers
heard.
matter, Lordship.
Two schools. The state was supposed to take some instruction in this
Yes,
matter.
yes.
Where is the state? With regard to the constitution of managing committee and all.
Yes, Lordship.
You wait, let the matter be called.
Lordship.
Item number 1.
Yes. The ID card on respondent number 2 has not been received.
Yes, my lord.
So what is to be done?
I may be allowed to publish in a newspaper, my lord.
No, no. Have you verified whether it has been served or not? Publication of newspaper comes later.
I'll have to go to the post office. I didn't get in the
You
net
have to
actually.
verify. You can track it.
Tracking,
also.
yes.
Nowadays,
I've been trying. Even
when once you find it is served, then you can obtain a certificate and find this.
well, I may be given 1 week's time. I'll track
Pass
it.
that order that you did. From the office note, it appears that the service report of restaurant number 2 has not yet been received. This is a report of service in respect of restaurant number 2 has not yet been serviced. Okay. Mr. P.K. Bora, petitioner, the verification one, the petitioner appearing person. Please for grant of some time to enable him to verify the status of service of notice upon the respondent number 2 upon the site respondent and to file an affidavit to that effect. Prayer alert list after 2 weeks. Meanwhile, you verify and just
Yes.
Item number 2. Hearing item number 4.
Yes. Yes, madam. You had difficulty, some difficulty here.
Lordship, Senior Conducting Counsel is leading us in this matter.
Yes, you obtained any?
Yes, my lord. The documents which are already annexed in the writ petition and in the counter affidavit and the additional affidavits are already there, my lord. Only thing what I could, the documents which are annexed here, my lord, it explains everything. Only thing on the last occasion I could not
explain. Means like the question was with regard to the
constitution of the managing committee. So there I am coming on that, my lord. Just a minute. My lord, will see on page 20, my lord, which my learned senior was referring to on the earlier occasion. Page 20
of the writ petition.
Of the writ petition was the constitution of the managing committee. Page 20. This was the constitution of the managing committee, which my lord has also pointed out that it was supposed to be valid till 31/12/2005.
Yes.
Yes,
the
my lord.
Petitioner has been shown as secretary.
Secretary.
As a
Headmistress.
Petitioner is a member here.
Ex officio member and headmistress. She was that time headmistress, my lord. And thereafter, my lord, when the dispute arose, my lord, when the dispute arose.
Number one, she was in the capacity of ex officio member or joint secretary.
An ex officio member is by virtue of the holding the post of headmastership.
But then headmaster was number 2.
But normal
whatever
so
petitioner was there. Then what happened?
Then, my lord, our stand is that, my lord, she was terminated, and my lord was pointing out that
yes,
how could they terminate?
You said that she has voluntarily left the school and started.
Yes, a separate school.
Separate school. Mr. Khan is also there.
Actually, my friend is.
Yes, it's all.
In case I am unable to, I would definitely think.
We may not decide the matter today in absence of the senior counsel for the other side. But then this
I'm
court
just
is
pointing out,
interested
sir.
to know. Now tell us what happened after, you see, so far as this court remembers, that the petitioner was terminated or whatever it is, she left the school during the subsistence of this managing committee. Now, if you say that she was not a part of the school thereafter, how could you allow this managing committee to run beyond the date of her termination by showing her a member of the...
My lord, in my affidavit, that affidavit itself, my lord, page 11, my lord.
That affidavit means which affidavit?
Affidavit dated 16/6/2019, additional affidavit, my lord, by which we brought the termination letter, my lord, issued by the managing committee.
Affidavit dated?
16/6/2019. It must be on 14 or 15.
16/6/2019. There is nothing. There is one 10/6/2019.
10/6 could be, my lord. It is by the administrative officer, State Education Mission Authority, my lord. Date of filing and the date of. My lord, I was referring to page 11, my lord.
Let's just find it. Okay, page 11.
Page 11, my lord.
Yes.
These are handwritten, my lord. It's not legible. With difficulty, will kindly allow me to read, my lord. An emergent MC managing committee
That was
meeting.
the thing, you see. That
My
is
lord.
where the problem came. We have seen that day.
No, my lord. Let me read out. No, so one paragraph only, my lord. Members of the Rajpur Girls Upper Primary School is held today on the 15th day of July at 11 am in the school premises. As the president of the managing committee is found absent, the quorum members unanimously propose Sri Noor Hussain to conduct the meeting and.
There is no type copy of this.
No, my lord. Sorry for that, my lord. Type copy.
How you are allowed to file it without having a type copy?
Yes, my lord. Type copy is at page 15, my lord. It is there, my lord, but in hurry, my lord, sometimes unable to point out, my lord.
Yes, yes, we can understand.
Page 15, my lord.
Yes.
The quorum members unanimously proposed Sir Noor Hussain to conduct the meeting, and under his presidency, following resolutions have been adopted.
Yes.
And by this resolution, my lord, the school resolved to terminate.
The question is that.
And those members, my lord was referring to the members, my lord.
The question is not that. Just try to understand it. Your constitution of managing committee was on 7th May 2020.
Correct, my lord.
And it was supposed to be for a period of
5 years. 3 years.
5 years?
3 years.
Okay, we take it.
3 years. 3 years, my lord. I stand corrected, my lord.
There must be something wrong in the vision.
3 years. I stand corrected, my lord. My apologies.
Now, if at all she had moved out, the petitioner had moved out of the school, how could she remain in the managing committee which tenure was up to 2006?
No, there I was coming
what
to.
you are showing, referring just now, is basically a record of a managing committee of a school wherein a meeting was held in presence of certain persons.
The quorum,
It doesn't say so. The question is that, was it that her name was struck off from the list of members of the managing
my lord,
committee?
again coming back to page 20, my lord, it says that 5 members shall form a quorum, my lord. Minimum 5 members is required.
You are not getting the question. What we
So,
have to do
so
with
the meeting, the meeting was very much valid, my
see,
lord.
this is not, question is not on the legality of page 11. Try to understand. This court is not questioning the legality and correctness of page 11 or the typed copy of what you have shown. The question is that how a person who is terminated from a school remains a member of the managing committee, which tenure is up to 2006.
No, my lord, what happened
Show us
thereafter?
something that she was removed from the managing committee after she was terminated.
No, there is nothing to show on that. What happened, my lord? Because of the dispute which arose, my lord, the school was put under the administration of the administrator, my lord.
Then you give us the details of all those law things.
So, my lord, these administrators and the managing committee for the first time came after it was put under the administrator was on.
Mr. Sengupta, you are unnecessarily making things complicated. The court's query is very simple. Do not try to, see, you will not get anything. You cannot pull this court.
The state has nothing to gain also, my lord. The managing committee is the.
See, once you are taking a stand, there is no question of gain and loss.
No, my lord, I am basically
taken a stand.
impartial, my lord.
Your case is that she has moved out.
She has been terminated.
She has started a new school by the same names, but in the original school, it was not the original school.
It is not the
Now,
original.
see, to attach approval or disapproval to a school, there must be a valid document, and that is what the managing committee's constitutional managing committee's document. You see, that would show who are the members. If she had continued as a member of the managing committee or part of the managing committee, then it will be an assumption that wherever she was, that is the original school.
My lord, I have made certain copies of it, wherein to show when my lord has also asked whether which school is getting the grant and aid, my lord. Certain building grants were also given, my lord.
Yes, what this court wanted, that which court is not about
No,
present.
which school is receiving?
How this school was receiving grant in it prior to the arising of the dispute in 2004, and who got it after that?
My lord, may I? I have arranged all the documents. Tried to arrange, my lord.
What is this?
My lord, these are deed of agreements, my lord. Page 21, my lord. It's bit.
The agreement will be signed by one person, isn't it?
My lord, I am coming to
how
that.
This court will know which? You tell us about the details of the agreement.
My lord, at page 12, my lord. Yes. At page 12, the 2 district mission coordinator, my lord. With reference to the subject cited, I have the honor to submit herewith necessary documents supporting the building grants, and it is addressed to. It is written by Sobida Khatun, the present person who is holding the post of headmistress. The Sobida Khatun school led by Sobida Khatun, my lord.
This is of which year? 2012.
2012. So this is the school.
This lady is the
headmistress.
Till now she is headmistress.
Yes, my lord.
And
and she is receiving all the grants in aid.
After the immediate, after the removal of the petitioner, who immediately became headmaster there in that school?
This Sobeda Khatun.
So she was there from that time.
From that
How
time.
do you say that she was there? On what basis you say?
My lord, this was done by the managing committee, my lord, and the managing committee from time to time has taken the approval and all.
Show us that she was appointed headmistress thereafter.
No, regarding that appointment, I have not brought the documents, my lord.
That is what
But
you have to show.
only thing which I tried.
We are not much interested to see on 2000. The court was right from the beginning was pointing out to you that we are interested to know the situation immediately before her removal and after her removal.
My lord, again at page 7, my lord, here also Sobeda Khatun is referred to as.
Give us the details of the bank account.
Bank account, my lord.
What is the problem of
bank account, my lord?
See, what is the
at
motive
page 26.
How you used to disperse money to the school prior to 2004?
My lord, at page 31, my lord.
The court is putting you a question. What was the manner of dispersal of money to the school?
The school to the school account to the account of the school managing committee.
So what was the account number at that point in time in which bank? Prior to the removal of the petitioner.
My lord, the passbook account number is my lord given at page 26, my lord.
That was there at that time. Are you sure?
Yes, my lord.
See, your submission will be recorded, and if anything is found wrong, remember you will be responsible.
I am making my submission on the basis of the documents annexed.
Do you know when this account was opened?
I have no idea.
Conscious submission?
I have not.
Which page you are referring?
Page 26, my lord. Because I have Xerox from the.
Court has put query, and then you must know how to answer that query.
I'll try, my
Yes.
lord. I'm always on the.
This is bank account.
Bank account, my lord. 011.
Which year this account was opened?
My lord, at page 27, my lord, yes. it says that 18 to. It's
4.
not.
18 to 4 is written there.
Yes, my lord.
Now, if you assume it 2004.
Yes, my lord.
Then you want to say that even till today, money is dispersed to
this account.
Okay. Now, who is managing? Is it 2004? Are you sure?
Yes, my lord. This is the Xerox copy which we have collected from the concerned officers, my lord. And this is the account which is receiving all the grant in aid, my lord. And here we have this page, my lord, where all the teachers and staff, they are receiving the payment, my lord.
When was the next managing committee constituted after 2004-1?
My lord, 2000, somewhere in 2013, my lord, I have.
2013. What happened in 2006?
It was under the administrator, my lord.
It was under the administrator.
Administrator,
From
my lord.
which period to which period?
My lord. Since, because the matter was sub judice, my lord, there was no managing committee.
Just tell us, what is the date of the removal of the petitioner according to you?
According to. The date of termination.
Anyway, be ready. This you don't think. When do you want it?
Lordship, I'm praying if this matter may be listed after a week's time.
Make sure you take it up. You see, like, we'll just should not be something like that. We go on adjourning the thing just like that. You see?
Lordship, I
You
pray.
take it back. You place
Yes,
it
my
in the
lord.
next instance.
As compiled.
Lordship, I'm also praying.
Yes.
Praying if a copy may be served to us.
My lord,
Yes.
we have just compiled.
Once we take it, then we'll see on the next day what will be. Okay, it is a kind of preliminary discussion so that you are prepared to run.
Lordship.
Anyway, just say Mr. S. Sengatto learned G. Learned additional senior G. Correct?
GM.
Senior, additional senior G or?
Yes, my lord. My lord is correct.
Additional senior G submits. that he has obtained necessary instructions from the respondent in terms of the order of earlier, time of the previous order of this court. Miss so and so appearing for the petitioner 6 grant of some time on the ground of absence of senior counsel appearing for the petitioner. Allowed a list after a week. Make sure you take it.
Lordship. Highly obliged, Lordship.
Item number 8.
Please, Your Lordship. Lordship, conducting counsel Mr. SN is also on his legs before courtroom number 2. He's on his legs.
You can take it up after this other matters, end of the board.
At the end of the board. Yes, any other matter? Yes, isn't it? Yes. It's a day. But then if nobody is appeared for these things, Mr. Day, yes, Day is there, is not? Yes. Yes, what is that item number 9?
Item number 9 is the same, connected with item number 8, Lordship.
You should point it out to the court.
Connected with item 8.
Okay, this also same order, 8.
Same.
Yes.
Item number 12.
Yes, Mr. Herrera.
Lordship, I'm for respondent number 2 and I'm appearing for the first time, Lordship. A short date may be given, we will file a reply.
Where is the petitioner? Why petitioner is not there?
Lordship, in fact, this is the second time they have filed.
Any interim order in this matter?
Nothing, Lordship.
None appears for the petitioner. Mr. N. Kher, Learned Counsel enters appearance on behalf.
Respondent number 2, Lordship.
And prays for grant of some time. Prayer alert list after 2 weeks.
In the meantime, I'll file my...
You can file it. There is no interim order, so nothing.
No interim. In fact, Lordship, this is the second time they have filed a similar application of the similar nature. Last time also they filed and then it was adjourned for a whole 1 year, date after date, and then they withdrew it. And now again they have filed it.
You cannot prevent them from
filing. Cannot.
So we have to deal with all the situations. We'll take into consideration all the submission when this matter is taken.
I'll file a detail. Obliged, Lordship.
Item number 14.
It is gone already over. It is
Yes, my
over,
lord.
madam. Court has passed order.
Yes, my lord. I'm aware. My apologies for not being clear, my lord.
Yes. Yes. What is the matter?
This is that petition which Lordship has heard in the last two occasions. Petition under 482 for quashing of the.
There's a non-compliance of 200, 202,
Oh, yes, yes.
203, 204. That issue. Only.
Yes.
So, Lordship had made a reference.
There is a query put by the court that where there is a non-compliance section 204 also.
204,
it's not
yes,
confined to this.
My lord had referred to a judgment of Justice Gawai. This is a very interesting issue, my lord. So, this was a complaint, my lord, by the state against company and its directors. So in that context, the court held that there was no positive averments with regard to the role and involvement of the directors of the company, and on that ground proceeded to dismiss the complaint as against those directors.
Was it the sole ground? You see,
I'm just
there
taking
are
the.
some
Your lordships will kindly have para 2, the first. I'll take your lordships to the facts of the case.
Yes.
Lordships have it. This appeal arises out of judgment and order dated 25th June 2015, passed by the learned single judge of the High Court of Judicature of Bombay at Aurangabad in criminal petition number so and so, thereby dismissing the said criminal writ petition filed by the appellants herein and upholding the order of issuance of process dated 30th March 2009, passed by the learned CJM Bede, referred to as the learned CJM, and the order passed by the learned Sessions Judge Bede dated 25th November 2014, dismissing the criminal revision, being criminal revision number so and so filed by the appellants thereagainst. The facts in brief giving rise to the present appeal are as under. The appellants are directors of Messrs. Cashit Pharmaceuticals Private Limited. CPPL was granted permission to manufacture Hemfer syrup, which falls under Schedule C and C1 of the Drugs and Cosmetic Rules 1945. On 30th August 2006, Shri N.A. Yadav, the then Drugs Inspector, Food and Drugs Administration, Bede, Maharashtra, visited the premises of Messrs. Priya Agencies at Bede and purchased Hemfer syrup, from which he had drawn samples of the drug. On 31st August 2006, he sent one such sample to the government analyst Maharashtra State Drug Control Laboratory, Mumbai, so as to have the drug tested. On 26th February 2007, he received a test report dated 13th February 2007 from the government analyst, stating that the sample was not of standard quality as the content of so-and-so was less than the permissible limit, that is 39% of the label amount. On the same day, the manufacturer of the drug, that is CPPL, was informed by a registered post about the test report. On 29th March 2007, Shri Vijay Jain, Deputy Manager, QA of CPPL, requested the drug inspector to send the samples again for analysis. Pursuant to an application filed by Messrs. Alchem Laboratories, the distributor of CPPL, the learned CJM
It
Bede.
is important to take into consideration all those facts there.
No, then I'll take your lordships to.
No, whether it is according to you, will it be relevant? Will it serve some purpose for us?
No, why I'm saying, my lords, that there were different officers of the particular company.
Kind of acquisition.
Lordship.
Just kindly come to that paragraph 38, where the proposition of law has been laid.
38? Yes, my lord. Kindly before that, just have 33, my lord. Para 33 on the top.
Yes.
It reads, it can thus be seen that there are no specific averments insofar as the present appellants are concerned. It is further to be noted that the present appellants are neither the managing director nor the whole-time directors of the accused company. Then I'll come to para 38. The order of issuance of process is not an empty formality. The magistrate is required to apply his mind as to whether sufficient ground for proceeding exists.
38 is not connected with 33. 38 is totally independent, general.
Yes, absolutely. Whether there is sufficient ground for proceeding exists in the case or not. The formation of such an opinion, now this is what is relevant. Formation of such an opinion is required to be stated in the order itself. The order is liable to be set aside if no reasons are given therein while coming to the conclusion that there is a prima facie case against the accused. No doubt that the order need not contain detailed reasons. A reference in this respect could be made to the judgment of this court in Sunil Bharti Mittal versus Central Bureau of Investigation, which reads thus. On the other hand, section 204 of the code deals with the issue of process. If in the opinion of the magistrate taking cognizance of an offence, there is sufficient ground for proceeding. This section relates to commencement of a criminal proceeding. If the magistrate taking cognizance of a case, it may be the magistrate receiving the complaint or to whom it has been transferred under section 192, upon a consideration of the materials before him, that is the complaint, examination of the complainant and his witnesses if present, or report of inquiry if any, thinks that there is prima facie case for proceeding in respect of an offence, he shall issue process against the accused. A wide discretion has been given as to grant or refusal of process, and if it must be judicially exercised. A person ought not to be dragged into court merely because a complaint has been filed. If a prima facie case has been made out, the magistrate ought to issue process, and if it cannot be refused, and it cannot be refused merely because he thinks that it is unlikely to result in a conviction. However, the words sufficient ground for proceeding appearing in section 204 are of immense importance. If it is there, it is these words which are amply suggest that an opinion is to be formed only after due application of mind, that there is sufficient basis for proceeding against the said accused, and formation of such an opinion is to be stated in the order itself. The order is liable to be set aside if no reason is given therein while coming to the conclusion that there is prima facie case against the accused, though the order need not contain detailed reasons. As fortiori, the order would be bad in law if the reason given turns out to be ex facie incorrect. A similar view has been taken by this court in the case of...
That's all needed, but then that is the proposition of law.
Yes, my lords, this is very interesting because I found also a slightly contrary proposition on this issue itself. Kindly see the last paragraph,
Yes.
41. In the result, the appeal is allowed. The impugned order of issuance of process dated 30th March 2009 passed by the learned CJM Bede and the order passed by the learned Sessions Judge Bede dated 25th November 2014 dismissing the criminal revision being so and so are quashed and set aside. The complaint against the present appellants, that is the directors, is dismissed. Needless to say that the complaint shall proceed against rest of the accused in accordance with law. Now this is to be read in conjunction with para 33 where the court has held, well, also there is no specific government insofar as the rule.
That is just for the reason that others have not come before the court.
No, my lords. It also says, my lords, that the case will proceed against the rest of them. It does not quash the entire proceeding.
This observation in para 38,
my lord,
it's totally general. It is independent of all those other aspects.
Right. Then I'll take your lordship to the next judgment.
That is what it seems. You see.
No, I understand, my lords.
You do not. You see, if you want to convince this court, you see, like just you see this court is not agreeing with you.
No, my lords. I understand. I'm coming back to this point again.
The court is not expressing any final view.
I understand.
The court is basically expressing you what this apparent understanding. You see, like what?
My understanding is, my lords, that in view of para 33.
Now we are concerned with, see, like if we, because this no two cases are seen, isn't it?
Lordship, correct.
So we may not get a case which covers the fact here.
Lordship, absolutely.
But then we have to draw the proposition. This is the general thing.
Yes.
What remains there is that when the court issues process,
Lordship,
it must be satisfied there exists a prima facie case.
Correct.
And then there should be a prima facie reason for it.
Yes.
Court doesn't have to pass any elaborate order.
Yes.
Now come to the order which has been passed in your case.
Yes. Well, it's just before that. Kindly indulge me, my lords. I'll just take lordship to the second judgment. It's a very interesting judgment, my lords. We're taking a slightly different course of this. This is a judgment from 2003, which has been referred to subsequently by the Honorable Supreme Court. So I will submit, my lords, my understanding of the judgment of Justice Gawai is that unless and until, because this relates to a company and its directors. So the complaint was filed against the company, which is an artificial entity, and they roped in all the directors. There the court came and said...
You want to make it fact specific. You want to say it is this observation made therein is confined to these things.
Yes, because this will be read with para 33.
That is what you will say.
No, not that. I'm saying the facts are somewhat different. So it may not directly apply to this case.
It's all right. But then 38 is a reiteration of what 204 says.
Yes, absolutely.
Independent of the fact of that case.
Yes. And just before that, Manoj, kindly have 203 and 204. Just draw a comparison between these two provisions. Because earlier we were just scratching the surface, but while reading all these judgments, I found there was some contradiction in this. So as Lordships had observed on the last occasion, after complying with 204, let's say the accused resides outside the jurisdiction of the court, they may call for an inquiry. And thereafter, proceed to the stage of 203, where if in the opinion of the magistrate, there is no ground for proceeding, they dismiss it. Now kindly see the language here, of 203. Yes. If after considering the statements on oath, if any of the complainant, and of the witnesses and the result of the inquiry or investigation, if any, under 202, the magistrate is of the opinion. Now kindly see, this is the same language used under 204. Is of the opinion that there is no sufficient ground for proceeding, he shall dismiss the complaint. And my lords, here is the qualification and the mandate for recording reasons. And in every such case, he shall briefly record his reasons for doing so. Now kindly see 204. If in the opinion of a magistrate, taking cognizance of an offence, there is sufficient ground for proceeding, and the case appears to be a summons case, he shall issue his summons for the attendance of the accused. I've gone through the rest. There is no such mandate for recording reasons.
So far as so far as the provision of CRPC is concerned.
Yes.
Now this 204 has been elaborated.
Lordship.
From time and again by the apex court.
Yes, yes, my lord.
That is what you see. There where if you see the starting line.
My lord.
If in the opinion of magistrate taking cognizance of an offence, there is a sufficient ground for proceeding. Now law mandates that there has to be
an opinion expressed. Yes, absolutely. So here, my lords, just kindly have the next.
No doubt. You see, like I don't think there will be any quarrel of views so far as this proposition is concerned.
Lordship. So
you want to say that it is not that elaborate as it is in 2003. The language. The requirement
language, the mandate, it's been discussed by the Supreme Court.
You want to say there exists a difference between language of 2003 and 2004?
Yes.
And you see, like the elaboration which is 2003 mandates, there is nothing as
in 2004. Yes.
That is what content.
This is what has been discussed.
But then probably, you see, like I don't think that, you see, like so far as the act is concerned, we understand.
Lordship.
But then if you go to the various interpretation of the apex court, especially the part which you have read out in
Lordship.
Justice Gawai's judgment.
Yes, Lord. Para 38.
Because it has referred to some other decision.
Yes.
There it has clarified it.
Yes, I went through Bharti Mittal. What they are referring to is Sunil Bharti Mittal versus CBI. That again relates to a company and its directors.
Right.
Again, the same context. There's another judgment of Mohan Meekings. Again, the same thing is in the context of the company and its directors. Now, here is a different case, my lords, relating to an individual. The second judgment, my lords, which is Roshan Agarwal.
Yes.
Roshan Lal Agarwal. Here, this is a very interesting matter, my lords. Kindly have page number 7.
This matter has become very interesting, Mr.
Yes, Lordship.
Page
7, internal page 7. Page 145.
Yes.
Para 8 onwards. Yes. Lordships have it?
Yes.
The second reason given by the High Court for allowing the petition filed by the respondents accused is that the order passed by the special court taking cognizance of the offence does not show that the learned magistrate had even perused the complaint or that he had applied his judicial mind before taking cognizance. The order passed by the learned magistrate reads as under. Kindly see this order, my lord. Cognizance taken, register the case, issue summons to the accused. This is what was recorded by the magistrate while issuing process. In determining the question whether any process is to be issued or not, what the magistrate has to be satisfied is whether there is sufficient ground for proceeding and not whether there is sufficient ground for conviction. Whether the evidence is adequate for supporting the conviction can be determined only at the trials and not at the stage of inquiry.
The same thing what has been read out in that.
Yes, my lord. At the stage of issuing the process to the accused, the magistrate is not required to record reasons. Now kindly see this. The question was considered recently in UP Pollution Control Board versus Mohan Meekings, and after noticing the law laid down in Kanti Bhadra Shah versus State of UP, it was held as follows. The legislature has stressed the need to record reasons in a certain situation such as dismissal of a complaint, which is 203, my lord, without issuing process. There is no such legal requirement imposed on a magistrate for passing detailed order while issuing summons. The process issued to accused cannot be quashed merely on the ground that the magistrate has not passed a speaking order. This being the settled legal position, the order passed by the learned magistrate could not be faulted on the ground given by the Honorable High Court. Now, I was under the impression, my lords, that this judgment would probably have been rendered per incuriam because of the judgment of 2003. Strangely enough, this has been referred to more recently in 2012 in the case of Nupur Talwar versus CBI. Because this is somewhat in contrast with the other judgment dwellers. So,
Which judgment will prevail over which one? Now.
So I think, Manoj, it's just on the facts.
These are judgment of the bench of equal strength.
Yes, that's the only issue. Now, in fact, this decision as well, there's a whole discussion on this Nupur Talwar's case, my lord. In fact, here, surprisingly, the issue of 465 and 431, all of that was discussed here, my lord. I'm just coming to that. Kindly have page 477.
Mr. Gautam must be also having some judgments.
Well, I have a judgment on merits.
You do not start. Only just ask. Court is asking. See, you have some judgments, isn't it?
I will place some judgments.
Yes. My lord has it, page 477.
Yes.
Para 11 onwards, my lord.
Yes.
This will require a little bit of time. A few provisions I'll just read out, few paragraphs.
Hope this court doesn't end up confusing.
May I read, my lord?
Yes, yes.
So, para 11 onwards, my lord. Undoubtedly, merely for taking cognizance and or for issuing process, reasons may not be recorded. In Kanti Bhadrashad, again this is the same reference to this judgment versus state of WB. This court, having examined section 227, 239 and 245 of the code of CRPC, concluded.
One second, Mr. Please don't mind. Suddenly it came to my mind.
Well,
is there a decision, like when there appears to be contradictory decision by the bench of equal strength,
Lordship,
decision which has been rendered at the first point of time,
that will prevail, yes.
You have that judgment.
I'm not carrying it at the moment, but that does
prevail. Then, I think that will help you in this case since you are referring to those.
Yes, Lordship. But what has happened is I've picked out 2 or 3 judgments. Now there are a series of decisions. Some say you have to record reasons, but then Roshan Lal starts with the fact that reasons are not required. And then it also goes on to qualify and say detailed reasons are not required. But if your lordships have noticed the actual order which has been reproduced, what it only says is
cognizance taken issue.
Yes, my lord. Barely any order. But lordships will find that there was no recording of even the formation of an opinion. There was no formation of an opinion. Now, just in that context, my lord, kindly have my complaint. I'll kindly have the revision petition that the 482 which they have filed.
Now, can it be something like that in even criminal cases? Well, we adopt the interpretation which favors the accused.
I don't think, because, my lord, here what's happened.
No, ultimately, if there is no other option, then court has to do that.
I would respectfully disagree, my lord. Kindly see the order which is under challenge, which is in the application under 482. Vastly different from Roshan Lal. Kindly have that order for a moment, my lord. So at least we'll have the context of where we're going.
Yes. Where is F? Where? F?
At page 101 of their 482 application. Page 101.
This will be needing some more deliberation.
My lord.
Yes.
So I'll just again read out what was in Roshan Lal, the order in Roshan Lal which has been upheld. It says, cognizance taken, register the case, issue summons to the accused. Now in contrast, this is what reads in the order dated 5/10/21. CR put up today, counsel for the complainant is present and submits list of witnesses. I have perused the statement of the complaint and kindly see this, deem it fit to take cognizance in this case. At least some formation of opinion is there.
Half sentence extension is there. It says that I have perused the complaint.
Yes.
There cognizance was saying. So once cognizance is taken, that means you have perused. This amount is this.
So comparatively, there is at least some formation of an opinion that she deems it fit to proceed in this matter.
See, if we go interpret both the orders, we cannot say that there is a formation of opinion. If we look into the judgment that the
Lordship, I understand completely.
Which says that at least there has to be some observance that there exists prima facie.
Yes, yes, Lordship.
If court says yes, peruse the record, there exists a prima facie case, issue process. That is all right.
Lordship. So that's not there here. Of course, what the magistrate says here, that the statement of the complaint has been gone through, I deem it fit to take cognizance of this case. So, to some extent, in comparison to the order in Roshan Lal, this stands on a better footing, in my humble submission, my lord.
And just another thing is that.
My lord.
No, that part will be taken care of by this 202,
yes.
That other judgment.
Yes, my lord. So, although while we are still deliberating on 204, that is because it fell from lordships on the last occasion.
No, because on the last occasion, after hearing you and Mr. Gautam,
Lordship.
see, moral what what transpired to the court is that there is an option of remanding it.
Yes.
That was probably thought understood. But then suddenly, well, after giving a thought into it, and then probably there was a statement which was wrong.
Correct, in the application.
Now, basically, that helped, basically made the court, formulate some different kind of thought.
Gotcha.
And then said, court, probably it was the prima facie at that point in time. It is not only a violation of 202, even 204 had not been complied. And if that 204 had not been complied, then there is no question of sending it back.
Correct. I've also, in fact, read the facts of these cases.
So that is how this matter was again.
Yes, Manoj. I've also read the facts to see whether, if any of the cases, the court was faced with the issue of non-compliance of 202 or 200 and 202. None of the courts were faced with that issue, which is why I was saying, once your lordships are satisfied with 200 or 202 has not been complied with, then the question of looking at 204 does not arise, because it affects the initial jurisdiction of the court. The order is bad for non-compliance of 200 and 202. We don't need to go into 204. But since it came from lordships, it's for lordship's satisfaction that we've gone through this. Now, this creates it opens a completely different can of worms. That one judgment says reasons are not required, and the other judgments say reasons are required. So, which is why, now the question is whether Roshanlal's judgment has ever been referred to by any of the other benches. It has been in that Nupur Tarwal's case. So, that is also a very interesting judgment, or not? I'll just come back to the judgment again. Page 477.
Yes.
Para 11 onwards, Manoj. Undoubtedly, merely for taking cognizance and or for issuing process, reasons may not be recorded. In Kanti Bhadra Shah, this court, having examined section 227, 239 and 245 of the Code of CRPC, concluded that the provisions of the code mandate that at the time of passing an order of discharge in favor of an accused, the provisions referred to the above necessitate reasons to be recorded. It was, however, noticed that there is no such prescribed mandate to record reasons at the time of framing charge against an accused. In UP Pollution Board versus Mohan Meekings, the issue whether it is necessary for the trial court to record reasons while issuing process came to be examined again, and this court held as under. Though the trial court issued process against the accused at the first instance, they desired the trial court to discharge them without even making their first appearance in the court. When the attempt made by that purpose failed, they moved for exemption from appearance in the court. In the meanwhile, the Session Judge Lucknow, Shri Prahlad Narayan, entertained a revision moved by the accused against the order issuing process to them and quashed it on the erroneous ground that the magistrate did not pass a speaking order for issuing such summons. The CJM, before whom the complaint was filed, thereafter passed a detailed order on 25/4/84 and again issued process to the accused. That order was again challenged by the accused in revision before the Session Judge, and the Session Judge again quashed it by order dated so and so. We may point out at the very outset that the Session Judge was in error for quashing the process at the first round merely on the ground that the CJM had not passed a speaking order.
That is all right. See, speaking order means is elaboration. But then that is not, this court is not talking about that.
Lordship.
There must be some indication in the order that the prima facie satisfaction is required.
Correct.
You see, that is, the court doesn't have to justify on
Lordship.
what basis this prima facie satisfaction is.
Lordship.
So we are not on speaking order.
Lordship. Then I'll take my lords to page 479.
479.
Lordships have it. Para 13.
Yes.
Where an order passed by a magistrate issuing process required reason to be recorded came to be examined by this court again in Chief Controller Imports versus Roshanlal Agarwal. This is the judgment I relied on earlier, wherein this court concluded as follows, and they've reproduced that particular paragraph, that passage, para 9 onwards. Then I'll come to para 14. Recently in Bhushan Kumar versus State, the issue in hand was again considered. The observations of this court recorded herein are being placed below. A summons is a process issued by a court calling upon a person to appear before a magistrate. It is used for the purpose of notifying an individual of his legal obligation to appear before the magistrate as a response to violation of law. In other words, the summons will announce to the person to whom it is directed that a legal proceeding has been started against the person, that person, and the date and time on which the person must appear in court. A person who is summoned is legally bound to appear before the court on the given date and time. Willful disobedience is liable to be punished under section 174 IPC. It is ground for contempt of court. Now section 13 is reproduced. Para 13. Section 204 of the code does not mandate the magistrate to explicitly state the reasons for issuance of summons. It clearly states that it is the opinion of a magistrate taking cognizance of an offence. There is sufficient ground for proceeding, then the summons may be issued. This section mandates the magistrate to form an opinion as to whether there exists a sufficient ground for summons to be issued, but it is nowhere mentioned in the section that the explicit narration of the same is mandatory, meaning thereby that it is not a prerequisite for deciding the validity of summons issued. Then kindly have the next page, Manoj.
That is in total contradiction of what Justice Gawai said.
Again, which is why I'm saying, Manoj, there is some contradiction in these judgments. Then kindly have para 14, the next page. Time and again it has been stated by this court that the summoning order under section 204 of the court requires no explicit reasons to be stated because it is imperative that the magistrate must have taken cognizance of the accusations and applied his mind to the allegations made by the police report and the materials filed therewith. Here I'll just pause and point out, in our case, my lords will find that the magistrate has recorded that she has referred to the statement of the complainant. So it's not an empty order where she refers to nothing at all. She says, I have referred to the statement by the complainant. And on that basis, I feel that I deem it fit to take cognizance of the matter.
So
that is the only distinction.
It means the only violation was 202. For that, matter can be remanded.
No, so there was a violation of 200 as well, as we have put it earlier, my lords, and also 204 because there was no inquiry which was conducted. But as far as, for the purpose of 204...
200 doesn't mandate that recording of statement is compulsory.
No, 200 says the person has to be present in court. Here, she had filed an affidavit. This is what was raised by the petitioner.
See, where the thing is that, come to 200, does it mandate for recording of... Oh yes, it mandates, isn't it?
Yes. So in fact, my friend was referring to a judgment of the Calcutta High Court, Rupayan Bhattacharya, where the courts have held that since that procedure has not been adopted, therefore it strikes at the root of it. Now, if Lordships recall, there I had pointed out reference to section 461 and 465 of the CRPC, whether it vitiates or not.
Not vitiate the trial.
Now, Nupur Talwar refers to that. I'm just coming to that. Kindly have the next paragraph. Para 15 onwards. It is therefore apparent that an order issuing process cannot be vitiated merely because of absence of reasons. Now, to what extent, well, that is debatable, it will be for the court.
The problem is that, you see, the use of language makes it more confusing.
It does.
Now, if you see the previous paragraphs, here it speaks about
detailed reasons.
We can understand.
Yes.
Reason is something elaborate.
Yes.
See, we understand. Even the Gawai's judgment also did not say that it has to be elaborate.
Yes. But there has to be some material.
Here in the same judgment, the two different languages.
Which is why I found it very confusing. And especially Roshan Lal, because Roshan Lal reproduces the actual order. And that the actual order barely has anything written in it. And they still upheld that order. That is a difficulty. And nobody has said that Roshan Lal's judgment is per incuriam or it is in, it does not consider any of the other previous judgments. It does not say that. Now, I'll just read further.
Any decision by a larger bench?
I have not found it. In fact, this one, this is same strength. In fact, even Nupur Agarwal is same strength.
Anyway.
Then let's kindly have para 16.
Yes.
The matter can be examined from another perspective. The CRPC expressly delineates irregularities in procedure which would vitiate proceedings. Section 461 thereof lists irregularities which would lead to annulment of proceedings. Section 461 aforesaid is being extracted hereunder. I'll just skip that and come to the next paragraph. In the list of irregularities indicated in section 461 of the CRPC, orders passed under section 204 thereof do not find a mention. Then also see para 17. In a situation as the one in hand, section 465(1) of the Code of Criminal Procedure protects orders from orders, omissions or irregularities unless a failure of justice has been occasioned thereby. Most certainly, an order delineating reasons cannot be faulted on the ground that it has occasioned failure of justice. But then again, they stop short of this. They don't say whether an order which has complete absence of reasons, whether that would fall foul of section 465 or not. But the understanding therefore is that in case there is an order where no reasons are assigned, it would not vitiate the proceedings. Now this is what Nupur Talwar discusses. But however, Justice Gawai's judgment, again, which is why I was referring to para 33, there the most important reason that prevailed upon the court was that there was no positive averment with regard to the role and involvement of the directors. That, in my humble submission, is the reason for the actual interference. Which is why they say that the matter should be remitted back, and as far as all the rest of the accused persons are concerned, matter can proceed. And the magistrate men look into the matter afresh. But as far as those directors against whom there is no positive averment, the matter had to be dropped.
Because it was a case challenged by those directors.
Yes. Yes, ma'am.
Others are not a party. So which way you interpret it?
So, why they had gone for quashing of the entire proceeding? Quashing for the proceedings.
That is definitely against them.
Yes, ma'am. So that is one part of it. Now, I think my learned friend is referring to a particular judgment, which is very recent, fellows, in the context of 498A. Achin Gupta. My friend will refer to it. I just want to make a very quick distinction, my lord. Here, the courts were concerned about the manner in which criminal proceedings are being inflicted upon the husbands and the relatives. These are all vexatious and they're used as a tool of oppression and harassment. My lord, Lordship will go through the facts of this case. I've just quickly perused it. This does not relate to the non-compliance of 200, 202, 203, 204. It is not in that context. My lords are dealing with the matter in a completely different context, purely on a point of law. So therefore, I would submit that this judgment may not necessarily apply to this particular case. This goes to the merits of it. And my friend's most important contention was that there is no averment against against the uncle, if lordships recall. It is the husband and the uncle who have been roped in. And we had referred to the allegations in the complaint. Just to refresh my lord's memory on that issue. The complaint is at page 26.
He pointed out something that he said something that
yes,
he will make her stay difficult and all those
yes.
things.
So that I would submit may come within the trappings of 506. It may track 506, but that again is for the trial court to consider.
This court may not go strictly into all those things.
Lordship.
See, like
Lordship.
if there is a mere statement also, if in absence of a total absence of statement, that is different.
So even on 204, my endeavor, my lords, is to submit this only, that even assuming the reasons are not assigned and it falls foul of 204, that reasons are required or the formation of an opinion is absolutely necessary, there must be at least a few words expressing the intention of the magistrate that she finds good reason or sufficient ground to proceed. Even if that is absent, it cannot result in quashing of the offence. At best, the order will be set aside and the magistrate will be given the opportunity to revisit the entire issue. It cannot result in quashing, my lords. I have not found a single precedent. As far as Justice Gawai's judgment is concerned, I said para 33 is what is relevant, that there was no positive averment with regard to the managing directors, the directors who had come before the court. There is not a single judgment, my lords. I have not found a single judgment which says simply because reasons are missing, the proceedings have to be quashed. It can go back, which is also the same case as 204. In Bank of Oman, same issue had been raised. Twofold grounds. One, that 204 has not been complied with, and number two, there is no offence that is attracted against the petitioners. There again, the court did not go into the merits of the case. It simply relegated the matter back to the magistrate for consideration afresh.
Yes. Well, as far as this judgment which have been placed before the court is concerned, my lord, we are on the same page because these are the only judgments we could find. Some say that opinion or a reason has to be made, and the others say that it's not required. But here, my lord, in this case, what is my submission is, if Your Honor will come to the imperial order, process under 204 has been issued on the basis of, if I may read, my lord, I have perused the statement of the complainant. Now that statement itself is on affidavit, which itself is illegal, my lord. So could the magistrate issue process on something which the law does not permit? No, that is the only submission left in the context of 204. Otherwise, my lord, the judgment which I have placed, the very recent judgment of 3rd May of the Supreme Court, my lord, here that is of course on merits of the case. My lord, Lordship had only asked us on opinion under 204. But I found a very interesting judgment, so I thought I should place it before this honorable court, my lord. Here, my lord, I will just read one paragraph from that judgment if Lordship allows me.
Yes.
Paragraph 25. The facts of this case are very similar to our case, my lord. If the entire FIR has been is there in the judgment itself. My lord, this is also a case of matrimonial dispute where, my lord, allegation of torture, dowry, whatnot, everything has been made. Now here, my lord, paragraph 25, what the court says is, and I've flag mark that particular page.
Yes.
If a person is made to face a criminal trial on some general and sweeping allegations without bringing on record any specific instances of criminal conduct, it is nothing but abuse of the process of the court. The court was a duty to the subject, the allegations level in the complaint, to a thorough scrutiny to find out prima facie whether there is any grain of truth in the allegation or whether they are made only with the sole object of involving certain individuals in a criminal charge, more particularly when a prosecution arises from a matrimonial dispute. Now, in this case also, my lord, what I submit is, my lord, only sweeping allegations have been made. Nothing else. And my lord, the reason why I say, my lord, this is an abuse of the process of court is because, my lord, we have a matrimonial a divorce case pending where a humongous amount of alimony has been asked. Subsequent to which, my lord, proceedings under the DV Act has also been initiated.
Now,
Thereafter, this
say
particular...
supposing one thing, if this court decides to remand the matter back, sir, complying, say for compliance 202, can this court direct that the statement be again recorded since there is no absence of...
Well, the court, since the person...
Now, 202, that National Bank of Oman will take care of this.
Lordship.
It can be remanded, that is what is.
My lord.
Now, as you say, that there exists no statement as such.
My lord.
It is only a piece of affidavit, which is not permissible under...
Not permissible at all.
Now, obviously, if it is remanded now, it is not only for compliance of 202, now then 200 also has to be complied with.
It has to be, my lord. To issue process,
Now,
it has
can
to
we
be.
direct for recording a statement?
Lordship,
To start the process from afresh from 202.
My lord, since mandatory provisions have not been complied with, Lordship, if Lordship does not even give a direction, if the matter is just remanded back to comply with the mandatory provisions, the court has to, my lord. That is in my opinion.
No, but then the question is that to that extent, can we?
What I say is, my lord, when
So,
the...
Sir, what do you say?
No, that's the only issue. On a reading of Rupa and
Say
Bhattacharjee,
supposing, now, this court, say supposing this court agrees with you, okay, we remand the way better. In view of the apex court's conflicting judgment is this thing, so we do not proceed till 2004. This court takes a safer route, 202, comes to 202, and the matter there and sends back the matter.
Lordship.
Now, while sending back, definitely then 202,
Lordship.
the mistake what has happened, you can cover it up.
Yes.
But then can it go back to 200?
200,
Asking to again the registration of...
So my answer to that is, my lord, that I was reading Rupa and Bhattacharjee. I don't find any other precedent on this issue where a statement has been recorded by way of an affidavit. I've not found any other precedent. But what Rupa and Bhattacharjee misses out is they don't refer to 461 and 465. It does not vitiate the proceeding. So Nupur Talwar takes care of that. For the first time, they've referred to 461 and 465, and they've said that you have to see whether a failure of justice is occasioned. If not, it does not vitiate the proceedings, and there is no need for any further interference. How are they agreed? How are they prejudiced? Is one of the biggest tests, my lord.
Failure of justice, which you interpret. In a criminal case,
well, at best,
compelling somebody to appear.
No, I'm not coming to that stage as yet. I'm still at the stage of 200. We're only concerned with the affidavit portion. So the magistrate does not require the personal attendance of the complainant. Instead, says file an affidavit. Does that necessarily cause any prejudice to the accused?
On the basis of
What
that,
is
I
the
have been
prejudice?
summoned.
What is the nature of the prejudice, fellows? We have to examine. We can't just make a sweeping statement that there is a prejudice. What is the actual prejudice? What is the actual prejudice? Because ultimately, the role of the magistrate in making sure that there is sufficient ground for proceeding is qualified and taken care of by 204 and 203 and 204, 202 and 204. So there are different checkpoints. Even in 200, assuming for a moment the magistrate does not require the personal attendance and records it by way of an affidavit, that is no prejudice caused to anybody. Because in 204, there is a check where if the person is not residing within the jurisdiction of the court, an inquiry will be conducted. Next, under 203 and 204, the formation of an opinion is necessary. So there are various stages at which the magistrate has to ensure and is duty bound to ensure that someone is not unnecessarily dragged into a criminal case. So all of that is taken care of. The code itself takes care of it. Now the question is, let's say 200 has not been complied with, but 202 and 204 are complied with. Can they claim that there is some prejudice, especially in view of 461 and 465? That is again a test matter which Lordships will have to examine.
The fact that, see, like he has to approach this court, that means he was dragged to the court.
Not necessarily, Malak. It's always the case of an accused that there is no case, please relieve me from these proceedings. It's always the case. We have several 482 applications which are dismissed.
Matter could have been something like that. Had there been proper compliance of the provisions,
Malak.
the matter would have been something
No,
different.
not necessarily. They would have still come up. In fact, in Nutpul Tarwar, I have gone through the entire case, the facts. The courts have said, this is the third time you've come up under 482. So it is always the case of the accused that something is wrong, there is a procedural defect, there is a technical defect, they always will come up.
That is in general.
Yes, that is exactly what has happened here.
But then
So there are two 482s that he has preferred.
conduct of different person
Yes, my lord.
cannot be clubbed
Yes,
together
absolutely,
to
absolutely.
make one.
It's a generalized statement, but then again, my lords, even if 200 had been complied with, 202 and 204 had been complied with, I'm pretty certain they would have still come up by saying the formation of the opinion itself is incorrect. The basis was not correct. They would have still come up. It's just that they have added arguments now that 200 is not complied, 202 is not complied, 204 is not complied. So I'm readily conceding. As far as 202 is concerned, I'm readily conceding. On 200, I'm to assist, my lords. I have not found a single judgment. Of course, Rupayan Bhattacharya is there. It has persuasive value. It has no precedential value. But then it does not
See,
take
if
into
the
account.
law does not contemplate filing of evidence by way of affidavit,
Yes.
what is the question of giving this?
No, then the question is, what is the consequence? Is the consequence a dismissal or revisiting, or do we look at 461 and 465?
If you see, if consequence becomes the ground of interfering or not interference with these things, then procedure will be given a.
No, I completely understand.
Go by. You see, nobody will look at it.
But then again, lordships are aware, procedure is only a handmaid of justice.
That is okay, but then when procedures aims to secure some protection to somebody, that
So
is
there, my lords, I'm saying, that is a test. I'm agreeing with lordship that is a test. Protecting the accused from unnecessary harassment in a criminal case. What is the prejudice caused? In case the person does not appear in person and an affidavit is filed, what is the actual prejudice? Because it is the duty of the magistrate to examine the statement
the actual
and
prejudice
conclude.
is just because of that affidavit you have issued process may compel him to this.
No, I understand. my lords. Now let's assume a case.
Say supposing, even if at this stage court quashes and
Yes.
sentences back, what it would mean?
They would restart.
That his dragging was illegal.
Lordship, yes.
You may
Well, I
be
wouldn't
given a
say-
fresh chance.
My lord.
But then the interpretation is that his dragging up to this time was illegal.
Not in accordance with law. Not necessarily, yes, my lord. Not in accordance with law. It's illegal. Yes, I concede.
This is different way of seeing.
I'm avoiding.
Is not ready to consider.
I'm avoiding an adverse observation against me.
No, see,
So I'll leave it up to lordships as far as 200 is concerned, only to assist my lords, because there must be some authority to assist your lordships to come to the conclusion.
you
that-
have not assisted. You have created more confusion now.
No, because I found it confusing myself.
Now you give us that decision, that earlier things. Of
Lordship,
the-
I'll look for that today.
That is one thing. And then Mr. Gautam, the 200 part. Can remand be to that extent?
I'll look into it, my lord. But
Remand can be for correction 202, but then 200.
that'll be the very basis on which the entire cognizance of the matter was taken. Now, whether two statements can be recorded, even if it's illegal.
Tomorrow you will not be occupied anyway.
No, I don't have.
So we can continue it tomorrow.
Yes.
Okay. Hard learning counsel for the petitioner. Further hearing to continue tomorrow. That put the date within the.
Look, all of this is because of the question that lordship has posed. But it's an interesting issue, it's a very learning experience.
It is. And in fact, these judgments of the Supreme Court also are quite confusing. One says something else, the other says. Maybe we have a
But it's
larger bench.
learning experience. This court has to decide it. See, that is the
Yes. Well, which is why I was saying.
Sometimes feels that on the other side you are more happier. See, when it comes to this kind of situation.
But which is why I was saying, perhaps it may not be necessary to go into 204. We can just stick to
That is
200 and
what, no,
202.
see, the court has not decided anything finally.
Yes, sir.
Only thing is that the thought which occupied the court's mind was that since someone has been issued, so that means 204 has been acted upon.
Yes, yes.
The issue of process is only
Under
204.
204.
Yes. So that is why the 204
Yes, Lord.
came to picture. The problem is that like there are many judgments, though contradictory, they are written in such a way, each one will give you correct interpretation.
Yes, yes.
Let us see if we can do tomorrow. We do not something.
Highly obliged.
Obliged.